So yeah, this is what I'm here to do today, is to sort of provide some insights on this question of why Wisconsin's judicial elections matter for Native communities. But of course, you guys are all the experts on what's important in your communities. So really what I'm going to do is just sort of talk about some different concepts, some different ideas, and some different issues that the courts deal with. So we can kind of understand together or work together to identify why these elections are so important for our communities. If you all are hearing anything about the judicial elections right now, it's probably about the Supreme Court seat. That's what's most in the news. That's probably tons of ads about it. I'm coming in from Denver, so I'm probably not getting as much as you are. So it is national news. And I will talk about the importance of that race in particular for Native communities. But I want to start broader than that and sort of get everybody in the room thinking about all of your views on what the proper role of a judge is in our society today. And sorry if it's kind of awkward with me running this slideshow, but I think we're going to manage. So anyway, to get people thinking about the proper role of a judge in society, I thought I'd start with this language. And does any brave souls, does somebody want to read this on the screen? And somebody?
I can read it.
Yeah.
So, I do solemnly swear that I will support the Constitution of the United States and the Constitution of the State of Wisconsin, that I will administer justice without respect to persons and will faithfully and impartially discharge the duties of said office.
Beautiful. You did that really well. Does anybody know what this is, or do you want to guess what this is?
That's what it's for, me, but
Yeah, good. So this is the judicial oath of office. So in order for any judge to take their seat on the Wisconsin Supreme Court, they put their hand up and they say these words. And I think for the most part it's pretty self-explanatory. Like, I'm going to be fair. I'm going to follow the Constitution. But I've highlighted this piece in the middle: administer justice without respect to persons. It's kind of a weird phrase, administer justice without respect to persons. Does anybody think they know what it means, or does it mean anything to anybody? I'll just jump in here. So generally this is understood to mean that judges should apply the law without paying attention to who a person is. So it's the idea that justice doesn't play favorites. If you're rich, if you're a celebrity, if you have political power, and you break the law, you're treated like everybody else. Right? You don't get special treatment. Another way that this concept is communicated is with the phrase "justice is blind." Has anybody ever heard that? Justice is blind. Some folks. So let me see a show of hands. Who thinks that our justice system should work this way? This is a good that people should take. Nobody? Everybody? Somebody? Okay, who thinks that our justice system does work this way? Nope. Resounding, right? So, and that's common. Many people don't feel like the system is really quite living up to that ideal. Even it's common, especially in communities of color. And there's evidence to support this. So, for example, consider people facing eviction from their housing. People in those circumstances are much more likely to be able to stay in their home if they have an attorney representing them. But all across the country, in eviction cases, it's usually the landlord that has an attorney and the renter that has no attorney. In almost no cases do they have attorneys. So this means that people aren't necessarily losing their housing because the law is fairly applied to them. They're losing their housing because they can't afford an attorney. Other evidence shows that even among people who commit crimes of similar severity, people of color receive longer sentences or harsher punishments than white offenders. with all of the harm that that entails for our communities when those folks go into the system. So, this idea, I think, of blind justice, it's critical, it's important that justice is applied fairly. And maybe in theory it's a simple concept, but I think it's really complex to implement and to achieve. And the reason for that is because our system isn't blind, right? Like, our system creates vastly different opportunities for people based on race, based on their economic circumstances, to adhere to the law's requirements and to ensure that justice is done in their case. So, at the highest level, as I start this conversation today, in a system, I think this is why in a system that elects judges, that it's so important for Native people to be involved in that decision making. Elected officials can't ignore, or they ignore at their peril, the people who have an impact at the ballot box. So, Native people face really unique and challenging structural circumstances because of colonialism, because of racism. And in my view, judges really need to understand that perspective and have it in mind as they work to ensure that justice is truly blind, so that our system administers justice without respect for persons. Okay, no. Is that where I am? No. Okay, so that's like my boom, we're in. With that sort of, framing for the conversation, we'll jump into the content that I'm going to cover. And here's a summary. First, I'll talk about just the basics of the Wisconsin court system, so we have that out of the way. What courts are part of the system, what do those different courts do? And then we'll just a little bit on how judges are selected in Wisconsin. And then we'll talk about why the courts matter for Native communities, why these elections are so important for us. And then I'll talk about how to have a say. How do we find the information we need to make informed choices at the ballot box so that we can make sure that judges are accountable to Native communities just like they're accountable to other communities. And I get nervous, so I have to have my notes. So if I slow down, that's what I'm doing. Okay, so starting with the court system, the main idea I want to get across here is that there are multiple levels of courts, and that they sort of play different roles or have different functions. At the lowest level here are the circuit courts, and this is usually where a case will start. So say you have a dispute with your employer, or you experience some discrimination and you want to have that issue resolved. Hopefully there'll be an attorney that you can work with, and you'll take your case to the circuit court first, usually. Circuit courts are called courts of general jurisdiction. Does anybody have a guess what that means? That's okay, I didn't know before I went to law school either. A court of general jurisdiction, it just means that that court can hear all kinds of cases. So they can hear cases having to do with state law, they could hear cases having to do with federal law, they could actually even hear cases having to do with international law. That case is brought before them. And they hear criminal issues, they hear civil issues, they can do it all. Civil issues are like, a contract dispute, or like I have a claim of discrimination, or any law that doesn't have to do with criminal law, basically a civil issue. They're also, circuit courts are the state's trial courts. Does anybody know what a trial court does? Okay, so you're watching a TV show about a court and you see a witness testifying, or you see an attorney entering the gun into evidence, or the fingerprint into evidence. That all happens at the trial level. The trial level, they review all the evidence so that they can determine the facts of the dispute. At the upper level courts, they don't do that. They don't accept new things into evidence. They just look at what happened at the trial level to understand the facts. So that's one reason what happens at the circuit court is so important. Like, all of your evidence comes in at that stage. In Wisconsin, what was I going to say? So in Wisconsin state court system, there's basically, for the most part, one circuit court in every county, and there are 257 judges across the 72 counties in Wisconsin. So the next level up, we have the Court of Appeals, and this court comes into play if the party who lost at the circuit court disagrees with the decision. Of course, they're usually going to disagree with the decision, but they think they have a chance of getting it overturned. Then they will file their appeal, and it's the Court of Appeals that will review that decision and decide whether the circuit court got it right or wrong. Unlike the Supreme Court, which I'll talk about in a second, the circuit court usually has to hear all of the cases that get appealed. So everybody would have the right to have their case heard on appeal at least once. So you get your shot at the trial level, then you could get at least one appeal usually. The highest level court is the state Supreme Court. This court also hears appeals, so challenges to lower court decisions. But the Supreme Court's review is discretionary. This means that the court decides which appeals it will and won't hear. So typically the Supreme Court just takes those issues that are the most important, or that are the most sort of controversial in the state. Last year, the Supreme Court heard 100 appeals out of 1,000 filed, so just 10%. Typically, the Supreme Court will take appeals from the Court of Appeals, but sometimes, I put this line over here, sometimes they can accept, or they will accept an appeal directly from the circuit court. But that's much more rare. There's one Supreme Court for the state, and 7 justices sit on that court. So across all these 3 levels, there are about 300 judges in the state court system, all of whom the voters elect. All of them, that's some way they elect. In summary, we have the circuit courts, which are the fact finder courts. They figure out the facts of the issue. Then we have the Court of Appeals, the next level up, who hear appeals from the circuit courts. And then we have the Supreme Court, who will hear a more limited number of appeals based on the ones they accept. There are other courts in the state that I didn't mention. There are municipal courts, so like the city of Milwaukee will have a municipal court. So other cities and towns will have municipal courts. And these deal with like local laws, the laws that your city council does. And for most people, what they would be most familiar with these as the courts where, like, if you get a traffic ticket and you have to go to court to deal with that traffic ticket, that's usually a municipal court. And then there are also tribal courts. These are not the focus of our conversation today about judicial elections. The tribes decide how their judges get selected, but they are important players in the administration of justice across the state, especially for tribal members. Okay. Who learned something about the court system? Okay, thank you. Good. Hopefully it was interesting. So in terms of judicial selection, unlike at the federal court level where the president appoints people and then the Senate says yes or no, or nothing in the case of Wisconsin judges are elected by the voters, as we said. So when you get your ballot, you may see candidates for municipal judgeships if you live in a city or town with a municipal court. You may see candidates for your circuit, for the circuit court that serves your county. You may see candidates for the Court of Appeals for the district that you live in. And then you may see candidates for the Supreme Court. And I say may because it depends on whether there's an open seat on the court that is that's contested, meaning more than one person is running for the seat. Judicial elections in Wisconsin are nonpartisan, which means you won't see a political party next to the person's name when you are voting for them. You won't see it on the ballot. So These judges, the judges aren't running as Republicans or as Democrats or as independents, though they certainly have their own political views. If there are more than 2 candidates running for a seat, there will be a primary election. And if needed, judicial primaries are held the 3rd Tuesday of February. So there was a primary last Tuesday. That was the 3rd Tuesday in February. And then the 2 highest vote getters for the primary move on to the general election, which is held the 1st Tuesday of April. So there will be a judicial election the 1st Tuesday of April. Supreme Court justices are elected to 10-year terms, and Court of Appeals judges, Court of Appeals and circuit judges are elected to 6-year terms. So they are on the court for quite a long time, especially the Supreme Court justices, although it's not like the federal courts where they have lifetime appointments. And then, of course, there are judicial elections happening this year. At the Court of Appeals level, a seat in District 1, which is, again, the district for the Milwaukee area, and a seat in District 4, which is the southwest, big southwest area of the state, are both open, or there are seats in both of those districts that are open and that will be filled. The District 1 seat is contested, the District 4 seat is not. And the District 1 seat is contested by a guy named William Brash and Sarah, I'm not actually sure how to say her name, apologies for that. And then, of course, there's the Supreme Court race. That seat is opened up because Justice Roggensack's 10-year term is ending. And the 4 people pictured here decided they wanted to run, or were running for that seat. Jennifer Darrow in the green, Everett Mitchell in the suit and tie, Daniel Kelly, or Dan Kelly, in the robe, and Janet Protasevich in the bottom right. Thanks. Good practice. They all decided to run. There was the primary I mentioned last Tuesday, and Dan Kelly and Janet Protasevich won the primary, and so they'll be running against each other on April 4th. NARC doesn't support or oppose candidates. Okay, so let's dive into this question of why judicial elections matter for Native communities. Again, I'll sort of start with the judicial system more broadly, and then I'll talk about something related specifically to the Supreme Court. Thinking about why judicial elections are so important, I think it's as simple as the fact that judicial elections matter because they determine who Wisconsin's judges are going to be, and those judges make decisions on many issues that are critical in our Native communities. So regarding voting rights, if somebody is claiming that they have been denied their right to vote, or that their community's votes are being diluted, so that they're not having as much impact, it can be a state court that decides whether that claim is valid and whether the court will take any action. A lot of times those issues do get decided at the federal court, but as courts of general jurisdiction, state courts can decide those as well. State courts also decide a lot of issues involving other types of discrimination, whether it's based on race, based on gender, or disability. State cases or state courts decide labor issues or employment disputes. If somebody believes that they were fired unlawfully or that wages are being withheld, those courts decide those issues. Courts decide, going back to the ICO point, they decide family disputes and custody issues, which are really central to keeping Native families and Native communities intact. And of course, they also work on criminal justice issues, or criminal issues. So diving a bit deeper into that area, state judges make decisions that impact ongoing discrimination in the criminal justice system. I mentioned at the start of my presentation that even when people of color receive, even when that people of color receive harsher sentences than white people, even when you control for the severity of the crime. And so likely reflecting this phenomenon, Native Americans in Wisconsin are actually incarcerated among the highest rates of any population in the state. And studies show that who was on the court can likely impact these outcomes. For example, one study found that white federal judges place more conditions on pretrial release than black judges. So if someone is charged with a crime, they can end up, and hasn't been convicted, no guilty verdict, they can end up sitting in jail if they're unable to meet the judge's condition of pretrial release, typically like payment of bail. Right? So if somebody doesn't have the money or doesn't know anybody who has the money to put up bail, they can be sitting in jail. So if somebody goes before white judges, they're more likely to be in that situation. It's more likely to be harder to meet the judge's conditions. Also, well, this isn't strictly related to criminal cases. Studies have shown that when a female judge or a judge of color is part of a 3-judge panel, so 3 judges are reviewing the case, their male colleagues or their white colleagues on the panel are more likely to side with the plaintiff who's claiming discrimination or claiming that they were discriminated against. So who a judge is really impacts their relationship and their perspective on these sort of structural issues in our society. And it influences the way they make decisions, and it influences the way other judges in their vicinity make decisions. And so that's why it's so important who's on our court and that they're as accountable to Native communities as they are to other communities. The way we do that professionally. Another area is tribal court jurisdiction. So this is also related to the ICWA point. But state judges also make decisions about tribal court jurisdiction. So that's when the tribal courts have the authority to hear a case, like the child custody dispute. So in the court case Teague v. Bad River Band of Chippewa Indians, the state Supreme Court said that you state courts, you have to work with the tribal courts to determine if tribal court jurisdiction is appropriate in a case. Should the case be heard in tribal court? And as we talked about a little bit, tribal court jurisdiction is really central to our ability as Native people to govern ourselves in accordance with our own laws and ideally our own cultural values. And I thought I'd play a short video clip if this works, to kind of signal how important tribal administration of justice can be to tribal people. So I don't know if this will work or if the sound will work or not. Try.
Starting point for me was a 13-year-old girl that appears in court for truancy. And the judge calling her case, the young lady approaches the bench, reads the charge, asks her how she pleads, and she says, guilty. The judge simply says, okay, I'll find you guilty. I'm imposing a fine of $90. You have 90 days to pay that fine. If you do not pay that fine in 90 days, your driver's license will be suspended when you're eligible to get one. That took around 11 seconds. When she came to get her paperwork, I said, young lady, why don't you go to school? She was a young Native girl, maybe 13. And she said, every morning when I wake up, my mother is with a different man. And my friends tease me. That's when I saw that system did not work at all. It took a young girl that was seeking help from a system that was supposed to protect her, and it punished her.
The video goes on. That's actually a video from NARF, the Native American Rights Fund Indigenous Peacemaking Initiative. And I encourage, if you're interested, watch the whole thing. It's really inspiring. They're talking about a lot of different models of Indigenous peacemaking. But the initiative focuses on helping tribes
Freaking busy.
set up
Nothing, I
alternatives
just made your
to
paper.
the Western style courts.
You didn't want
And alternatives that allow tribal communities to resolve disputes in ways that follow our traditional values. So those are values like caring for everybody in the community, or preserving or restoring community bonds when things break down because of conflict or dispute. So as I was saying before, our rights as Native people to self-determination are really best served when the administration of justice aligns with those traditional values. But state courts, state judges are involved in deciding when we get to be before these courts, right? When we get to be before our traditional system. And of course, those decisions have to follow the law. Right now, they still have to follow ICWA, which says tribal courts have jurisdiction in disputes involving Native children. But I think it's really important for judges, for those state court judges that are making these decisions about tribal jurisdiction, to understand the importance of tribal sovereignty and self-determination and what those things mean for the well-being of our communities. I think they're way more likely to get to the right decision in those cases under the law. Super glad that worked. Oh no, now I can't advance.
Starting point for me was,
Okay, so now to the Supreme Court. Of course, the decide who sits on the Supreme Court is no less consequential than the rest of the courts, and and the other judges that make sort of some of these decisions we've been talking about. Is anybody familiar with any recent decisions of the state Supreme Court? Anyone see anything in the news perhaps? Yeah.
Did they do something about line 5?
That's actually in federal court. It's okay. Yeah.
I feel like they made a lot of decisions with COVID and this.
Yeah.
I can't remember what they were, right? They decided like what cities or government would.
Yeah, so one thing that they did around COVID-19, well, as context, the governor, tried to, in order to stop the spread of COVID-19, tried to do things like the mask mandates, or the safer at home orders, or and then there was a pared down order a bit that focused on capacity at bars and restaurants. And the Supreme Court did get involved there, striking those things down, saying that they were sort of unlawful uses of power for the administration. So that's one big way sort of the Supreme Court has influenced outcomes in our society recently. They've also made big decisions impacting democracy. Another thing that the governor did around COVID-19 was, not the governor, sorry, the Wisconsin Election Commission, which sort of administers the election rules in the state of Wisconsin. They had issued guidance saying that election officials could use ballot drop boxes. Okay. So people could vote by taking their ballot to a ballot drop box and putting it in there. The guidance said that the box had to be secure, and it had to be monitored, and it had to be emptied regularly. But the Supreme Court got involved there and saying that ballot drop boxes were prohibited under state law. A big impact on access to voting. The state Supreme Court was also got involved in sort of a back and forth in Wisconsin over the voting districts. And so voting districts, let me see if I can explain this simply, but they have a really big impact on who gets elected. So if you think about, there's a Native community on a reservation, if a district is drawn around that community, they will be able to vote together to select that community's candidate of choice. But say the district is drawn and that community is split apart, in each split district, they're added to other non-native communities. They may not have enough voting power in each of those individual districts to elect their candidates first. So how legislators draw the line really impacts who communities can or can't elect. And so voting rights advocates like NARF, like the NAACP, will often use the courts to make sure that natives or Black Americans or Latinos or Asian Americans are protected in that process and the votes aren't diluted. So again, their courts can play an important role in making sure that happens fairly. What's another one? The court did, they weren't doing line 5, but they did in 2021 have a consequential environmental decision, which said that the Department of Natural Resources in Wisconsin had to use its permitting authority to protect Wisconsin's water resources. There again, another sort of oversight mechanism for the way that the state deals with natural resources. So the court's making really consequential decisions for the state, and these are issues that are very much matter for Native people: voting, democracy, the environment, COVID-19, and public health protection. And the court will. Oh, sorry, I had a slide on it. It's not a super detailed slide, but there you go. And the court will decide on critical issues going forward. Some of these are super hot button issues, but likely topics will include a decision on the legality of Wisconsin's old criminal abortion ban. It wasn't allowed under Roe v. Wade, but now with that decision overturned at the federal level, I think this is likely to come up for the state court. Decisions on gun regulations, decisions on LGBTQ rights, perhaps a decision on the legality of state laws that have weakened labor unions in the state. And
Cannabis?
maybe, yeah. I guess I'm not as familiar with that issue. It does happen in certain areas, but possibly. So restrictions on access to reproductive health care and the creation of new crimes, rebalancing of power between business and labor. These are issues that are definitely heavily debated across all communities and nationally. But they can really have disproportionate effect in Native communities as well. So it's really important that our judges are held accountable to the Native people as much as they're held accountable to any other group in the state as they're making these important decisions. And I'm a voting rights attorney, so I'll spend a little bit more time here. I think as the video talked about, we're the first people of this land they call North America now. And many of our people talk about us being here since time immemorial. But we are the last group to gain the right to vote. And ever since, and even after we supposedly should have gained the right to vote in 1924 when Congress said all you Native Americans are citizens, states continue to deny Native people the right to vote. So for example, a lot of states had laws that said Native people are under guardianship of the federal government, so they're under guardianship and so they can't vote. Other states said Native people can't vote unless they leave their reservation and renounce their membership in their tribe. And that happened all the way into the 50s. Ultimately, it wasn't until the passage of the Voting Rights Act at the federal level in 1965 that Native people could use the courts to push back really at all, the federal courts really at all, against tools like English literacy tests and other types of things that states were using to prevent Native Americans from voting. So it's really only very recent, and like a lot of our lifetimes, that Native people, had a right that they could take to court and have a meaningful defense, to have it honored. And in the current day, and even with that, in the current day, NARP has identified many ongoing voting barriers for Native communities. Has anybody in this room ever had trouble voting, whether it's like trouble getting off work to vote, or it's a long distance to the polling place, or you showed up and were turned away? Okay, so a couple people. Yeah, so we see that kind of stuff across the country for Native communities. We see structural issues like, long distances to polling places, long distances to that place where you have to go to register to vote. A lot of times communities will lack access to internet, so you can't go online and say, what's my polling, or where's my polling place, or what do I, how can I register online, or what kind of ID do I need to vote or register? So, all of these things can just make voting more costly and more time consuming for folks. And we also see that ongoing bias and racism lead to things like election officials providing less voting information or fewer voting resources for reservation communities. And then we also see on top of that, state legislatures passing laws that make it harder for natives to navigate the structural barriers that we face. Not allowing ballot drop boxes, not allowing ballot collection. So, like a Native organization to come and pick up ballots from remote Native communities or from Native seniors and drop them off for vote. So when these issues come before judges and have to decide whether a law is violating voting rights, the Constitution says they have to look at the severity of the burden, like how hard is it actually for the person to vote because of this voting law. Or the Voting Rights Act requires judges to look at whether there's a discriminatory impact, whether it affects Native or other minority groups more than others, than whites. And in my experience, judges are most likely to get that right if they have an understanding of what Native people are going through, or minority communities are going through. And again, that takes us back to the reason why it's so important to be involved in these elections, so judges know that Native people are watching them, are watching their decisions, and are sort of hearing our voice around why it's so hard to vote and how these decisions should be made under the law. And because I don't like to just talk about the bad news, I also want to give so much credit to how Native people, in the face of all these barriers, are fighting back and taking political power where it has been denied to us. In recent years, Native people are running for office and winning historic elections. We have sort of 3 Native women. 2 of them are the first Native American women ever elected to Congress. The third was the first Native Alaskan woman to be elected to Congress. Native candidates have been winning historic appointments. So in the middle is Deb Haaland. She was the first Native American ever to be appointed to the president's cabinet as the Secretary of the Interior. And I'll focus on her a little bit. The Department of Interior is doing work that I don't think maybe never would have happened around tribal co-management of public lands, around boarding school reconciliation. It's really important work at the national level for Native communities because she's in that position, and she's brought a lot of Native leaders into the department to really implement that work in a way that resonates with our communities. So when we have that representation in positions of power, it really does make a difference. We're really able to be heard as Native people, in our different institutions of government. Also, Native voters are making a difference in election outcomes. It can be hard, in a lot of areas. We're really small communities, but in Wisconsin, Native communities have been credited with making the difference in major statewide elections recently. The presidential election in 2020, the governor's election recently. Native people come out, and when we come out, we make a difference, and when we make a difference, they have to listen. Right? And so that's the same thing that we can do for these judicial elections. Okay, I think I'm on my last slide. So how do we do that, or how do we start to do that? Judicial elections are hard, right? Because a lot of judges' work isn't done in as public of a setting. A lot of those trials, like nobody really sits through trials to see what a judge does. Very few people like will listen to oral arguments at the appellate courts and hear what kind of questions judges ask. So how can we make informed decisions? How do we know what judges are doing and how it might impact all of these issues that we talked about? And I feel you, it's hard. But there are things we can do, and I sort of tried to put the things we can do into 3 steps, and I think as we practice them, as we use them more and more, we can get more familiar with the ways to really evaluate these candidates and make ourselves heard in those elections. So for step 1, it's really just decide what you're looking for in a candidate. Think about what issues are important to you. We talked about issues that the courts are deciding on. Think about what qualities you want in a leader. Do you want them to have worked with particular communities? Do you want them to have particular type of legal experience? A particular amount of years serving as a judge? And then what candidate? That's messed up. What judicial philosophies do you want your candidate to have? And so this might go back to the first slide, where there are some judicial candidates or judges who really think like we shouldn't be paying attention at all to a person's circumstances. We can get everything out of just the letter of the law in order to ensure justice is made in the case. There are some judges who really think that we can't do true justice unless we're paying attention to those circumstances and to those structural issues. And so where do you fall on that? And in terms of what the judges say about themselves and their candidacies and their judicial philosophies, how does that align with how you feel a judge should conduct themselves and make decisions? Number 2 is learn about the candidates. And again, this is, I think, the really hard part, or can be the hard part. But you're going to look for things like what are their qualifications, what types of jobs have they held before, how long have they been judge or justice. And a lot of it is just look at a lot of different things, right? You can look at their websites, which of course is how they package themselves, so you take it with a grain of salt. They're saying the things on their website that they think their voters want to hear, most likely. But even then, you get a sense of who the person is and what their values are, and you can see if your values align with them. The links on the slide, and we'll send this, everybody has, I'm happy to send this set of slides out to anybody who wants it. But the links on the here, those link to their websites. So there's the website for Daniel Kelly, Janet Brash, and Gini. And then, and one thing that I find the most helpful about candidate websites is they usually have a link for who's endorsing them. And so you could get a sense kind of who they are and what they stand for by the people and the organizations that endorse them. What I think is most helpful is the organizations, because then you can go and look up that organization, see what kind of work they do, and I think that's where I get the most sense of whether my candidate aligns with my values. If they're endorsed by an environmental rights organization, or by Planned Parenthood, or by gun rights, or by police, you can sort of get a sense of where a candidate falls on the ideological spectrum based on those endorsements. And again, you can find that if you go to the candidate website and then you look at their endorsements.
Thank you, Allison.
Yeah.
Absolutely wonderful. Great job. I learned a lot.